குட் மார்னிங். யார் பார்த்துக்கிறா இன்னைக்கு? நீங்கள் 2 பேர் தான் பார்த்துக்கிறீங்களா? எனக்கு அந்த யூடியூப் லிங்க் வாட்ஸ்அப் பண்ணி விடுறீங்களா? பண்ணிவிட்டு பண்ணிங்கன்னா நான் ஷேர் பண்ணிவிடுவேன். நான் எடுத்து அதை அனுப்புறதுக்குள்ள அதுக்கு அங்கே எடுத்துகிட்டே இருப்பாங்க, யாராவது எடுத்து பேசுவாங்க. அவ்வளோதான், வேறு ஒன்றும் இல்லை. சரி, நான் வரேன்.
A very good morning to everyone. I would request all the participants to please settle down. I would request honorable dignitaries to please join us on the dais. Now I request Ms. Uma Maheshwari Madam to please come and introduce our guest for session 1, Honorable Mr. Justice Bharat Chakravarti.
Good morning. Good morning, my dear colleagues. I'm really honored here to introduce Justice Bharat Chakravarti. He's another gem from our college. As his name goes, Bharat Chakravarti. Chakravarti is a person who is on the top and the helm of the affairs. You would be knowing, like Chakravarti Shivaji Rao, like that way. He is also a person like that. And he was in our college right from, he was 1988 to 1993 batch. And after his studies at our college, he had gone to Chennai. And at Chennai, he has been practicing both high courts, tribunals, and even the subordinate courts he was there. And he had a firm. My husband used to be telling me, see, Bharat Chakravarti is doing a good job. And we wanted to refer some cases. Of course, we did not refer, but he used to tell me, you remember, sir? Stephen, you remember? He used to tell me, see, our college, he's having a firm and he's doing a good job. So he was having a firm along with Justice Ilandirian and I think it is Sai Krishnan, all these people. And we should also recognize, like, see, a person selected from the bar, what sort of effort he should have put so that the bench has recognized him and he has been given an opportunity. I'm really honored to introduce him to you, though he's not a person new to us. Then, when he was practicing, he is an expert in mediation. Arguing for our clients is different, but making peace with the two people is quite difficult, I feel it. So he has done a great job in that. And while he was doing mediation, he was also, for just from 2 years, from 2005, he was doing mediation. In 2007, he himself became a trainer for mediation. And he is a trainer right from 2007. And he has trained many mediators, and there are a lot of referrals. Around 400 referrals has been made by him. So kindly give him a big hand. He is a joint secretary. He was a joint secretary and coordinator to the Madras High Court Mediation Center. Then he was again his next step for his improvement is he was in the arbitration, and he was empaling in the Madras High Court Court Arbitration Center. He did not stop his career like only practicing and handling cases. He went a step further, and he's even an academician. Like, he has authored many books and articles. Like the first one, and to my awareness, is Seek Mediation. It is an awareness booklet. It is about the Tamil Nadu Mediation, booklet for the Tamil Nadu Mediation Center. And he has also co-authored with another person, Sriram Panchu. This, I think, is a mediation at the Madras High Court. Then another article, like, I think it's an article, sir. It's a Madras High Court journey from, yeah. He has authored another article. It's the journey from the Crown to the present Madras High Court. So this is a long history. It's a long case, like how the British was there, how the Indian courts came into existence, and how we are all, how we are doing about all these things. Then he. And the next point is that mastering one language is itself quite difficult. But he's mastered in both the Tamil, English. I don't know what other languages he knows, and he has translated this book into Tamil. Mediation Manual of India. So he has also authored another chapter, community mediation, in the book Mediation Policy and Practice. Okay. The next thing is he did not stop there again. Again, he has jumped into the modern technology. He has an app, Lift. So Lift means it is law in the fingertips. So it is an app wherein it is free of cost. It is bilingual, I understand. Bilingual, free of cost educational app. So anyone can use it for their enriching their knowledge. If you are really interested, the students can also use it. Next, he is also a trained volunteer at the Madras High Court for gender sensitization and internal complaints committee. So Bharat Chakravarti Justice Bharat Chakravarti has gone to a great height. I'm really honored to introduce him to you, and my prayers for him, like he go to greater heights and honor us all. Thank you, all of you. You have a good session.
Should we give you a portable mic? Not a portable mic. If you have a collar mic. No. Next is. So see. No. Previous one. First. Yes. Start with. And then the second is the link. Now, so double click. Yes. Okay. The internet connected to that.
Yes, sir.
Oh. So good morning, everybody. I'm audible. So looks like we are continuing from the last year. I saw you, most of you, in the last year's session. Good to have you here back in Puducherry, and especially on behalf of my college, I welcome you all once again to Puducherry. Thank you, Mama, for the introduction. She is my immediate senior, therefore that bias, therefore she is spoken already. All right. So my topic for today is ODI, Online Dispute Resolution, a new frontier for consumer justice. That's what it is. All right. This online dispute resolution is not something very big. Okay, because we are already having this little experiment with reference to consumer. See, from the year 2016, Ministry of Consumer Affairs, in association with the National Law School, Bengaluru, set up an online mediation center for resolution of the consumer disputes. So that's going on from 2016. That is a unique experiment. Ministry of Consumer Affairs, Government of India, in association with the National Law School, Bengaluru, has just click on that.
Yes, sir.
That's a link only.
Yes.
Go to the website. All right.
How do you have one minute, sir?
So That is there going on from 2016. Now, secondly, now last year, all right, you can visit that website. The university and the students, they are doing this thing online. Mostly product complaints, all those small claims. They are dealing with this from 2016, and it is an ongoing experiment only. It is not something new. Therefore, the National Law School has been doing that. Secondly, go back. Second thing is that now again the Ministry of Consumer Affairs has even invited expression of interest for private players to provide a secure platform for conduct of consumer mediation. You have the tender itself has been invited. I think the date is also over. I don't know. I couldn't contact them to know about the exact position. Therefore, sooner or later, the Ministry of Consumer Affairs is going to come with its own platform for online dispute resolutions of consumer disputes. So therefore, we know the thing. Therefore, it is going to come sooner. It is going to pick up in a very large way. All right. That is the invitation where they have asked for call for tender, and then now this thing. Go to next slide. All right. Now, what do we mean by online dispute resolution? Online dispute resolution means alternative dispute resolution. More specifically for us in consumer, it is more mediation only. Alternative dispute resolution online, and it includes all innovative and technology driven methods and practices. Okay, so by ODR, online dispute resolution means resolving the disputes in an amicable manner through the ADR method. See, section 20 the Act says we have a whole chapter now amended by the Mediation Act relating to mediation. You know, the district consumer has the power to refer the cases to mediation after the complaint is admitted and notice is served, and the same power is there for the State Commission and the National Commission. Therefore, that mediation which we are going to conduct in an offline, we are thinking about an online scenario. So online means that the ODR means that the dispute resolution in the form of the alternative dispute resolutions, and it also includes all innovative and technology driven methods and practices. See, it is not very that there are varying definitions relating to ODR also, because every year it changes what it means and how it is going, because it is technology driven. There is all the time improvement and changes. Therefore, it is even difficult. They say it is even difficult to define even what ODR means. Yes, now go to the next slide. All right. Essentially, ODR is of two types. Okay. It is of two types. One is the technology enables the human intervention. Okay. So through online platforms, through technology, we the human beings do the mediation. Okay. The second one is that completely technology. By using artificial intelligence, we know the chatbots and other things. Okay. Essentially, online dispute resolution is of two types. One is the supportive technology. Second one is the substitutive technology. The one first technology supports us in doing mediation or whatever the form of the alternative dispute resolution, be it Lok Adalat or mediation. Or the second one is it totally substitutes the human being. Technology itself does the process. Therefore, essentially these are the two types of online dispute resolution. Go to the next slide. All right. Now, in the past, I don't know about tomorrow, until today, the types of online dispute resolution can be broadly classified into three forms. Okay. First is the blind bidding mediation. I'll explain it to you later. The second is the narrative mediation, and the third is multi-session face-to-face mediation. Okay. Broadly, so far the online dispute resolution which is being done can be classified into three types. See, those who want to take down notes, you are comfortable, you write. Otherwise, I will also share these PowerPoints with you. The copy of this in a PDF form will also be shared with you. So, some people are learners by writing, therefore you can write it down. Otherwise, only for remembering, if you are taking notes, don't worry, I will be sharing this PowerPoint in a PDF form also. Alright? So, these are the three forms of ODI. Go to this. Now, first, blind bidding mediation. This is like they normally have a portal where the user registers himself, and then, for example, I ordered say for example a pressure cooker. I purchased it for 2,000 rupees. That is not working. Therefore, the company or the person has a portal. I just enter into user, then I enter the billing details. All right, this is my complaint. How much I want? I blindly bid. You pay me 3,000 rupees. That's all. Company has also a value for all that. All right, this is more appropriate for the small claims and the product related consumer disputes. This we call it as the blind bidding mediation. There is no great deal of negotiation. There is no interface. There is no consideration on the dispute. Therefore, you enter all these particulars in a portal. All right, what did I purchase? What was my complaint? How much I want? And then the money, they also have their own standard. And they'll say, all right, 2,000 sanction will pay. This is called as one method. This is called blind bidding mediation. This is done through web portals and filing of forms. They have like Google Forms. They have a set of forms. We fill it up and then this thing. It has its own advantages and disadvantages. Advantages in the sense that it's very quick. It is very quick, no botheration, and then it is more suitable for a small claim like 1,000 rupees. You ordered a small product for 500 rupees. It's not working. It's not even worth going to the shop again. See, those things, where will you go? If you only purchase a product only for 200 rupees and it is not working, it is not even worth going to the shop by wasting 2 liters of petrol. So that is the great advantage of this blind bidding mediation, because the small claims can be easily settled. Disadvantages are that when it requires explaining, it may not be of a great help. Alright, go to the next. The second form is called as a narrative mediation. Okay? In a narrative mediation, what happens is that first they receive the message. Okay? The affected person sends his complaint online through the portal. Then they call for a written brief. All right, what exactly is the problem? And then what do you want? How it has to be resolved? I purchased that, say for example, this television 45. All right, what is the problem? It doesn't get connected to the Wi-Fi, or I am not able to connect it to the other pictures. Therefore, I give it in detail. All right, then it goes to the mediator. Then mediator, what he does is that he reframes the entire brief to the company, because a person affected would normally say, this is a fraudulent set which has been given to me, totally a useless product which is given to me. Those kind of things will be there. Therefore, he reframes the entire thing and then sends it to the person in writing, everything on mail only, mail and in writing only. And then he gets their reply. All right, what they can do? They are going to send their service personnel or to replace the set, or they are going to repair, or still whether warranty is applicable or not, whatever the reply the person says. And then, he carries the communication back and forth, and ultimately a solution is arrived at. This is called as a narrative mediation. Go to this. In a narrative mediation, normally the procedure followed by them is that the first is to acknowledge the effects of the conflict on each person. Okay, how did I suffer? purchased after all a new television. I wanted to see the India-Australia match. Therefore, I suffered. Okay. Therefore, acknowledge the effects on the person. See, mediation in law is all about disorder. It is more recognizing the emotions and the ordeal the person went through. That is what even in any, in every consumer dispute, there is a lot of emotional thing which is going on behind it. It is not just about money alone. It is not just about money alone. I arranged the marriage for my son. Therefore, I ordered a modular kitchen. It was not installed in time. If it is not on the day of the marriage and when the new daughter-in-law comes, I won't do that. Therefore, there is a lot of emotional issues when it comes to consumer affairs also. A builder, I gave him my property, thinking that it will be ready by so and so day. I have arranged so many of my personal affairs. Therefore, it is a lot of emotion which is involved. That is why they say they acknowledge the effect and then describe each party's perspective of the dispute, which serves again as an acknowledgement. Again, back and forth, and then what you wonder about the possibilities. What are the manner in which it is said? You generate options basically, and then put across to each other. So that is how narrative mediation is conducted. So you then summarize and then ask the parties to reflect on what happened, and then pose questions and remind and compliment them for their proper participation, and then the solution is arrived. This is all done in writing only. This is when the email first came. First, it was implemented only for this product-oriented complaints and the other things. So, narrative mediation is also one of the earliest form of mediations in time online dispute resolution. Sometimes it works also. As a matter of fact, in one of my mediations, not relating to consumer disputes, in one mediation, we had several sessions and we are not able to settle. We are almost in a closing time. That was also done online. But then I wrote a mail after that. Very good. Thank you for participating. We had 4 sessions. This seems to be your concern. This seems to be your concern. Ultimately, we are not able to bridge the gap, or we are not able to solve because of this. Anyway, thank you for your part. I wrote one of the parties detailed mail. And then Pat came with me. Today, now also, sir, even this comes, we can settle. Then I forwarded to the other. Sometimes, after orally failing, some things in writing also can, in some scenario, help, because there is more clarity of thought. So that is the advantages for narrative mediation is that, see, you avoid unnecessarily trading of allegations, and then when you put it into writing, parties come to the point and the disadvantages are when somebody wants to express emotions. Okay, some things can't be said in writing. Some things can't be expressed in writing. So that is where it gets its disadvantages. All right. Next. All right. The third type of online dispute resolution is the multi-session face-to-face mediations. Okay. So whatever mediation which we do in a private room, we are going to do on an online platform. Okay. There, see, the mediator is there. Party A, party B, both the consumer comes and the service provider comes, and the mediator mediates, but however through online mode in some platform, say for example Zoom, or even on a WhatsApp video call if you don't have other platform, or a Cisco Google Teams, WebEx, or whatever platform. Therefore, now in the multi-session face-to-face mediation, the most important thing which we all have to take into consideration is that apart from the 3 parties, mediator, party, there is a 4th party called the computer and the in-between internet. Okay, so that is the advantage as well as the disadvantage of the face-to-face mediation. We'll see that a little more detail also next. Yes, go to the next slide. So for face-to-face mediations, we all know that there must be an internet-enabled device. So that itself, in a rural scenario, okay, in a rural scenario, the parties don't have that device, then that may be a problem. Second is you should have the systems and tools, that is the regular platform or whatever it is. Then the third important thing is that the privacy and the security of the information. So whenever something that fourth party is present, okay, in a mediation room, mediation is all about confidentiality. And then once the fourth party, that is the computer or the system or the platform, then the platform provider comes, whether there is a backup, whatever being said is being recorded or not. So that is the privacy and security issues. Because in mediation we say that it is being conducted in a private manner, in a separate room, secured and with a confidentiality. So whoever who is outside, they are outside the mediation room are not supposed to know what is happening with mediation. And finally, the awareness, whether we are all equipped, the whole of our country is equipped to participate in such a platform, and whether they are participating in good faith. These are the two challenges. Yes, go next. See, essentially, when it comes to online dispute resolution, the dilemma is between the contact theory and communication theory. That is what we say. Now, the effect of mediation itself is that if I have a dispute with sir, okay, we both are brought into the same room. We come to face, we negotiate directly. Somehow that physical proximity is supposed to help for resolving the disputes. Now, in an online platform, now that physical proximity is not there. Okay? So, we are not at the table, but we are around the table. That is the basic difference in an online dispute resolution. See, whatever I may say so many allegations sitting in front of a computer from my own bedroom or my living room. I will not say that much of a thing in the presence of you being the service provider or the manager or my builder or whoever I am having the relationship, when you are present and sitting together within 3 feet. That is the basic difference between an offline resolution and an online resolution. Now you are at the table in an offline resolution, but you are around the table in an ODR method. Here there is physical proximity, that you have to show something called a digital empathy only. Okay? So physical proximity, like, all right sir, don't worry, I supplied you the goods, all right, just say that also. There is so many things can be sorted out by a gentle body language also. What is missing in an online dispute resolution is that body language. See, human beings, we tend to communicate a lot through our body language. Okay, that is missing. So what they say is to somehow equalize that, what is called as digital empathy. So how do we empathize with others digitally? Itself is a detailed subject. Now when you are in an online session, especially in an online mediation, how one expresses oneself. Yes. Yes. Emojis, okay. Alright, see. Okay, netiquette matters. Okay, alright. There are some netiquettes which we follow. We can say emojis. Alright, we raise our hand quite often. The smiley is good. Alright, the clapping is good. It serves the purpose many of the time. This is not. Somebody speaks very well. You just click on that button thing. So that also serves the purpose. You put a thumbs up. I agree with you. Thumbs up. Okay? Therefore, those are the methods by which now the digital empathy has to be shown. More importantly, the parties have to express verbally whatever they want to say in detail. And then we must understand the thing called internet uninhibition. Okay? When it comes to an online dispute resolution, especially face-to-face mediation, don't think that they will not open up or pour out. As a matter of fact, what they say is, it is called as internet uninhibition. You will open up more, you will come out with more. Parties will create more allegations only on an internet platform. See, that is how most of this, even the other sexual related offences also happened that way only. See, we had a case, as they say that one of the calls of this lady was recorded in an inappropriate position, and then they abused it. That was the case, criminal case against them. The husband was saying, even in a private room with me, she will not behave like this. I don't know why she behaved like this. That is a very issue. It can happen to me, it can happen to you, it can happen to anyone. That they call it as internet uninhibition. What we will not do in a physical scenario, we will do in an online mode. See, you have the privacy of your separate room, and then you think that nobody is there. It happens in an online mediation also. So what happens is that they have the internet uninhibition, and then normally they take more charges also. What they say maybe 10% when they are in a physical mode. When we conduct a mediation through online, they tend to speak more, as a matter of fact. Yes. So, what are the advantages and disadvantages? Okay. So, in a face-to-face mediation, so as we discussed, what are the disadvantages? What are the disadvantages you can think of for conducting a mediation offline and online? What are the disadvantages you can think of? All right, it is easy to communicate face to face rather than online. All right, that's we are used to it. This is a new thing. Therefore, there is some person will be finding it difficult. All right, yes. Anything else? What are the disadvantages you think of? All right. That will do even in the physical scenario also, no?
But it doesn't happen when every time we face to face, we meet.
Okay.
We record something.
Ah.
But when the company through the online platform, they covered everything.
Okay.
They wanted us to feed everything in the.
All right. The retention capacity may be less in an online platform. Therefore, all right. Yes. Anything else? Human touch. All right. Sometimes we may lose that human touch. Yes. Anything else? People may not be tech. All the person, everyone will not be tech savvy, so they don't know how to, even keep their camera, even if they have a mobile phone, how to do it. Some persons put the light behind their thing and sit like this only. Their faces are dark, so they don't know how to conduct themselves. They don't know etiquette also. Leave alone that they don't have internet connection, they don't have electricity. That is another thing. All right. Connectivity issues are all right. Technical issues. When I am narrating something very important, then like in court, am I audible, my lord, only? All right. So therefore, there may be issues relating to understanding the thing. All right. Yes. Anything else? You may miss all right. Miss the elephant in the room also. All right. Yes.
We are not committed when we are in
You feel non-committal. Okay. You think you can escape. You can say anything and you can escape. Emotions will be missing. Very good. All right. Then what do you think are the advantages? சொல்லுங்க. Okay. Distant physical clashes, the other party slapping or biting his ears, all those things doesn't happen. All right, that is one thing. Okay, all right. What he is saying is another important thing. What he says is that some person may be very forceful and aggressive by his stance. Okay, when he comes near me, I am a little bit timid only. Therefore, little bit of those things are equalized in when I sit in my own privacy, in my own this thing. I am not that intimidated by his presence. All right, then. We can. All right. We can enhance. All right. Other materials can also be shown. The documents can be uploaded and it can be focused. We can be more focused. You are saying. I can even prepare something like that. Some notes like this. Very good. So convenience is one of the important things, because if I have to come to the Consumer Court Mediation Center, nobody is going to keep it open for me at 7 p.m. Therefore, one party is in Singapore, another party is here in Puducherry. Therefore, the time difference is also there. He wants it at 11 o'clock and I want it at 7 o'clock. Therefore, those things, timing convenience is there. Very good. Distance convenience is there. We save a lot of money. Okay. Already I have to come to, say for example, my consumer case is in Vijayawada. The company headquarters is in Delhi. So every time that representative has to fly and go back. Therefore, energy, money is saved. Paperless, all right. Time is saved. Time is saved.
There is also an advantage. These expenses they can settle the matter quickly.
So if it is a smaller claim, for example, the claim itself is 5 lakhs, I would be spending 6 lakhs on the airfare. Okay, we save on the manpower. Yes. Anything else? Okay. If necessary contents can also be recorded and it can be rewatched and reworked. All right. That can be at both an advantage and disadvantage also. Good. Yes. Anything else we can think of?
The success stories can be, repeated so that the public will gain more confidence to come forward for more mediations.
Okay. All right. Success stories can be repeated. More and more people can participate. That is what they are saying. See, even in a real life scenario, now originally we had the physical scenario and then we have the online scenario. Now our regular working itself is becoming hybrid. All our courts are becoming hybrid, and we are now starting virtual courts also. The regular working itself is becoming virtual only. So that is one of the most important thing. Then technology can enable people to participate from wherever they are, and we can connect and then do the mediations with less expense. Yes. It can be we can quickly resolve the cases. There is no question of coming for court. That is what, for example, even in a consumer court, that is what our chairman presented there in Delhi. Now, in one court in Theni, that is in deep south in Tamil Nadu, if a doctor treats a patient in a simple hurt case, a criminal case, and then by the time the case comes up for trial, he gets a PG seat in AIIMS, Delhi. Okay? So, for giving evidence, when he will come to Theni, it will take 2 years to bring him. Whenever he is free, only he can come. And the cases get similar in consumer court also. Medical negligence case, there may be an expert who need to depose the evidence. And then or even when he is in far off places. So for him to come, he would have gone abroad also for some higher courses. Therefore, we keep the matters pending. Therefore, those delays are avoided. All right. What else you think are the advantages? Now, how do you think that for consumer cases in your court, I want you to close your eyes and think. We said that the three forms of ODRs. Now, if you have to adopt from tomorrow, which is the form you are adopt for what types of consumer cases, which forms you will adopt, or you think that this is the only form which I can use or this cannot be used?
First of all, we don't have that facility.
Okay.
Today.
Yes, that is why I want you to close your eyes and dream only. Tomorrow you have the facility. You close your eyes and dream, and I am sure that before 2025 we are going to realize that. All right. That is good. Therefore, as we are planning to use technology for adjudication and in our regular thing, now when you think of mediation, see, as he says that we are in the nascent stage only, the Mediation Act itself has not come into force. The relevant provision which substitutes the Chapter 5 of the Consumer Protection Act may come into force before we go also. Tomorrow also will come. We'll ask the law minister when he is going to come in the evening. Therefore, any time it is going to come. See, they have now notified few sections because though they want to have the mediation council and the administrative setup in the first place. See, the sections which are all notified are relating to the act has come into force. Then number 2, the chapter relating to the establishment of mediation council and the administrative setup and the creation of the consolidated fund, etc. are already notified. Therefore, they want those setup to be there. And then once it is notified, everything can be taken up further. That is why it is notified in a phased manner. It will come, it will be notified on any day. Then once it is notified, the Mediation Act will replace the Chapter 5. It is more or less similar only. The only thing is that originally it has to come to you for recording. Now that will be an enforceable decree by itself. So we have our own consumer, we all know that the Consumer Act now will be substituted by the Mediation Act, and then the consumer rules, which is the mediation rules, which is framed by the central government, and the regulations framed by the National Commission. So these three, the setup is already there for the mediation. Now, as on date, Chapter 5 only. As on today, Chapter 5 only. When it comes into force, once it is notified, then it replaces the thing. That is the methodology. Everything is mentioned in the Mediation Act. After all, what the Mediation Act says that what are the matters which can be referred to mediation. That is Section 6, and that is contained in the schedule. What is relevant for the consumer is that all consumer cases are referable, but those professional complaints, for example, a medical negligence case with reference to compensation is referable to mediation. But the complaint which is given to the medical council as against the doctor for his professional negligence, that cannot be settled. Therefore, in a mediation agreement,
Grievous. That is grievous. Then it is not.
no, now as per the Mediation Act, new Mediation Act, all right.
It should be made mandatory. Mediation is not mandatory as of now.
Yes, not mandatory as of now. What I am saying is, under the new Mediation Act, Schedule 1 says that what are all the cases which cannot be referred to mediation. in which any professional complaint against an advocate to the bar council, against a doctor to the medical council, against a chartered accountant to the respective council, those professional complaints, it says that it need not be mediated. So that is taken away from the pursuit. Therefore, how it will be relevant in the consumer case is that when they enter into an agreement, say in a case of medical negligence, they will agree on the compensation, and then normally the clause will also be that they will withdraw the complaint before the medical council also. So that we have to be very aware of once the new act comes into force. As on date, there is not a problem. Once the act comes into force, every matter relating to consumer is referable to me. So what can be referred is enumerated under section 6, and then it enables it lays down the procedure how mediation has to be conducted, which is not very different from your chapter 5. So it is the same thing only. Mediator has to assemble the parties. Everything is confidential in an informal manner. He has to settle, and then previously the judge has to pass an order recording the compromise. Now under the Mediation Act, the agreement, once it is authenticated by the mediator and issued to the parties, or if it is an institutional mediation, it goes to that is Consumer Court Mediation Center. If it is given to the center itself, like a Lok Adalat award, it becomes a final by itself, and it is enforceable as if it were a decree of the concerned court. As if it is an order given by the Consumer Commission, it will be enforceable. So that is the difference between the Mediation Act and the existing Chapter 5. Not much of a difference with reference to the core value. The core procedure is not altered by the Mediation Act. So principles of confidentiality, and then it is without prejudice to the case, and then it is informal, and then self-determination by the parties, all the same only. What is different is the methodology or the procedure finally recording, and additionally they can also register, if it is a pre-litigation stage, they can register it with the mediation council just to enhance its authenticity. Any pre-litigation stage also, parties can go for mediation, and if there is a settlement, then it can additionally it can be registered with the mediation council so that it becomes authentic, some kind of a registration of a document kind of a thing. The Mediation Act is, that is the only difference. Otherwise, the basic procedure and the principles are one and the same. All right. So far, as far as the ODR history is concerned, see, we all know that, you know,
practical side, as per the act, we have been asked to appoint mediators and we have appointed them also.
okay.
Separately for the motion of court. But on real basis, what happens is, when it comes to the question of fixing of the fees, there is. When it comes to the question of fixing of fees, there is an issue and parties don't agree, and we are once again forced to refer the matter to DLSA, Legal Services Authority, based.
There is a resistance from the parties with reference to fees.
Yes, for
All right. What does our regulation say? The National Commission regulation. What is the regulation relating to fees?
parties have to pay.
Parties have to pay. Parties have to pay.
Yes.
All right. All right. So therefore, that is the parties are now not willing to pay. All right.
Yes.
See,
So practical problem.
even with reference to other mediations, the rule. Please sit down. We will discuss that. See, even with reference to other mediations, the High Court rules which are prevalent is that the parties have to pay only. But in the initial stages, we want to proliferate mediation. Therefore, the NALSA is giving fund for giving honorarium by the courts. Okay, we don't want to, burden the parties. Therefore, a similar scheme has to be given for the consumer courts also, where the consumer mediation centers mediators are paid honorarium by the consumer commission itself rather than asking the parties to pay. That is what you are saying. That may be by a discussion or whatever the thing, we can send the message to the government, because even for example, even in Tamil Nadu or Puducherry in the regular judiciary, the mediation centers are there. mediators are being paid honorarium. Honorarium is paid partly from the Nalsar fund and then the respective governments supplement it. Every year they give a grant. For us in Tamil Nadu, 6 crores the government is giving an annually. Therefore, we are distributing from that fund and the Nalsar fund only. As a matter of fact, as you rightly say, the rule is that only the parties have to pay the honorarium of the mediator. Therefore, you don't have the provision for funds. Alright, that has to be taken up with the government. That's a practical difficulty, I understand. Alright, then, yes, we'll do something about it. Therefore, you can, then you are referring to you are again referring to the DLSS. Alright. Because the funds are from NALSA. If they conduct on their umbrella, they can give the honorarium from that fund. If you are doing it in the Consumer Mediation Center, then that is something the Ministry of Consumer Affairs should take up. Alright, we'll take up.
Lordship.
Yes. Yes.
Regarding the mediator's fee, in the Consumer Act itself, there is a scheme, Consumer Welfare Fund. As per the Welfare Fund scheme, 25% has to be contributed by the state government. Remaining 75% has to be paid by the central government. In respect of Puducherry concern, central government granted 5 crores this year. Last year itself, state government granted 5 crores. So it has been deposited in a welfare fund scheme. Out of the interest, we are paying fee to the mediators. That has to be adopted in all other states. That is the thing.
Okay. Then you have a solution. Yes. Alright. That is not. They are not spending it. That is the thing. In most of our court systems, the problem with our is that whenever you go and ask for the fund to the government says already you are not spending the amount which are given to you, then why do you want more? That is how they cut the budgetary allocations. Therefore, as he rightly says, that first spend that welfare fund. Okay. All right. Good. They had a session on this fund also, funding with reference to consumer courts also. Then we have to have a separate module for that also. Srinivasan will take note. Next year that will be there. All right.
The scenario is in some of the states, though the government has allotted a place, the funds are not forthcoming from the government, the state government. Some other places, the government is yet to allot a place for the building. So there is it is continuing
infrastructure is
infrastructure. In fact, before the Honorable Supreme Court, public interest litigation is pending as of now. My learned brothers and sisters know about the litigation. One of the major issues is that the infrastructure are not provided throughout the country in some of the states. Status reports have been asked to be filed by the respective states. It is still pending. And it concerns a lot of issues. Amongst the major issues is that infrastructures have to be provided for the consumer courts. So the government has to take it in such a way that the consumer law has gained by leaps and bounds. So it is imperative that it has its own building, etc.
When the Consumer Act 2019, when they enact, they should also see to that whether appropriate infrastructure is there.
Yes.
Allotted,
Yes. That bill is pending. As of now, it is pending. It also deals with recruitment of staffs to the consumer court and also the presidents and members. So a lot of issues are pending. So your motor petition is pending before the Honorable Supreme Court. So the difficulty is that how to get the funds, how to get the land for the consumer court. So unless the
government, as a time bound, in a time bound manner, it has to be, I would only request the government to, take care of the issue in an urgent manner.
Maybe
So that the,
part of this 2-day symposium, they can summarize all these issues and send it to the government.
is to the concerned state government, I'm saying. In fact, we are also operating from a rented premises only. A lot of consumer courts are,
Yeah, we all know that constraints of the.
Yes.
You can sit and talk.
Thank you.
We all know the constraints of the infrastructure also. As he said that we are talking about ODR, we don't even have a facility. Maybe we didn't have an internet connection to a particular port also. So in that scenario only we are saying. I always give this example, like we the judges in India are like this bird only. It doesn't have a proper, tools or anything. But we call that Tupran Guru Kudu, that the bird's nest you must see. Yes, that's. It will be silky. It will build only with the twigs of leaves and other things. But it will be as silky as a very sophisticated bed. Like that only we judges with the available infrastructure. We have to give the best to the litigants who approach
in
us.
fact, I was hesitating to take it on record.
Good.
But,
No. See, one thing we keep, there are two things. One, we keep pushing for appropriate infrastructure.
Yes.
Always ask the government to give us, and at the same time, not put the blame on the availability of the infrastructure and not to implement anything which is good for the litigants. So both will carry out together. That is the important thing which we all have to bear in mind.
In spite of several issues, all the consumer forums are doing their human service.
Yeah,
So that has to be not only in Tamil Nadu, in other places also.
Yeah.
So we are waiting that the government has to take in an urgent manner. That is our humble request.
No, that's a good thing which I'm saying.
Because ultimately-
we had a 2-day program. Maybe we can all collate what these are the things which we discussed. And these are the things which we requested, and then we can put it in writing. I'll ask Ms. Srinivasan to do that. You all give whatever the thing we'll think also, we'll collate and then we hand it over to the Honorable Law Minister who is going to come. And then they will look into it and redress the issue also. See, incidentally, our request is reference to infrastructure and the other things. Therefore, you can say, some High Court judge is coming and talking to us about ODR. We don't even have a computer, please provide one. Therefore, you can say that only. Alright. Yes. Therefore, now, coming back to the topic, alright? We digress a little, it's good for that, alright, we'll come back. See, we all know that the history, to know about the history, how it happens, we all know the internet history also. 1969, the internet was invented, and then World Wide Web in the year 1982 or 84, and then 92 the first portal, then 94, then from 2000 the e-governance, everything came, and now we are in the arena of artificial intelligence and virtual reality and things like that. So that is the history of the internet and the computer usage. As far as ODR is concerned, first they opened a thing called Internet Ombuds Office in Massachusetts, and the first case is also given in that portal. If you want, you can see. These are some of the popular portals worldwide. Across jurisdiction, they settle consumer claims and disputes, Cyber Settle, Square Trade Portal, and several conferences relating to ODRs were conducted, and then the small claims portal, European Union regulations also included ODR practices. Now some of the popular websites are Montreal, Smart Settle, Adjust Claims, etc. There are so many private players who are providing platform for settling the disputes online. Yes, please. Anything else? Okay. All right. I'll try to come back with that. I don't know the answer. I'll try to come back when Lordship is taking the session. I'll do some research and come and give you the details. I didn't know the percentage of how successful they are. Yes, I'll give you the correct answer.
In our
file the complaint in their courts, files dispute resolution, whatever that form they fill and they come there, they have 2 or 3 sessions, and then they come back to the commissions. So the efficacy of this system is really questionable. And like yes, the amount we paid is also questionable. And we have collected a huge amount in our legal aid fund. And several letters we have addressed, but we don't get any feedback as to how we utilize the money. We are having a substantial amount in our legal aid, but there's nothing to utilize.
Point well taken. So first, it would be of some use to know out of 100 cases how many are settling and the balance are coming. That is one thing. All right, I try to ascertain what is the how they are claiming these private portals. Many a times you don't know. They will not be divulging the exact portals. Then, as far as our consumer court centers, what do you think is the percentage of settlement? Not even 1%. All right, let us go. This thing. All right, which is your court? Chengalpattu court. All right, how in the consumer court mediation center, how many cases are on average as referred? Do you have any statistics? Refer. All right. Most of it is not settling. Okay. Then that is something which we have to look into why it is not settling. That is something.
As a mediators, when the matter is referred for mediators, the advocation parties are saying that the court fees, no court fees up to 5 lakhs. When the government itself is saying that no court fees 5 lakhs, why you want to pay 1,000 rupees for mediator? So we fix it 3 mediators, so that they have to pay 3,000 rupees. When they want to pay the 3,000 rupees, immediately the advocate and parties are saying that the government is provided up to 5 lakhs, no court fees. When there is no court fees for the 5 lakhs, why you want to go for mediation? The Act says that the disposal only within 3 months. So that do it in 3 months. That is the reason and also we request the state government to put honorarium to the mediators. But government is not fixed it. Even the National Commission, once it is conducted workshop, they demanded, no, not only 1,000 rupees, fix 30,000. And I told, sir, 1,000 it is the main pay to the district courts. Because it is a national consumer court, the advocate fees itself is 10 lakhs for appearance. They don't mind it is the companies of Samsung and other, they will be ready to pay 50,000 or 60,000. Here 1,000 is the main problem, sir, in lower court. That is the problem, sir.
Do you think that the honorarium is the main problem which is blocking? Therefore, I also request you, the honorable judges, to go into this. Now, ascertain whether it is a non-starter or how many cases both parties come after payment of fees to the consumer, how many cases in which the mediation is conducted and whether it is settled or non-settled. So, we have to classify into 2. For example, in a national average, in respect of all other disputes, say civil cases, including family cases, everything. See, for the average in Tamil Nadu and Puducherry is generally it is 17%. 17% of the cases is getting settled. If so, there is no reason why it should be less than 1% for consumer alone. The problem is then we have to see whether it is non-starter or whether the both parties are coming to the table and then not settling. Then you have to divide it into 2. Therefore, when you are referring, as you say that I understand that in most of the cases they don't even pay the fee of the mediator, it is coming back to you. That is one thing. All right, that has to be, as he says, that you look about the consumer welfare fund, and then we have to take up with the government also to that. Mediators. Yes. Yes. That is also there. Good, good. See, that is also a good thing only. That we all the time you do. And even if it goes for mediation, many a time that bridging the gap will not be there. When the case comes up before you thereafter, that's it.
Because we are having the market capacity than media.
Okay.
Ultimately, we are going to decide.
See, that is a little bit of dangerous things only. Therefore, being in a position of power and asking them to settle, okay?
So
that is where the very concept of mediation is to give them a free hand to negotiate with the other side, empty all their emotions, and think what is good for them and agree with the solutions. Many a times, as judges, even if we say openly, now I am only doing mediation, don't worry about the case, you talk to me freely. Parties won't. They know that you are in a position of authority. So therefore, see, settling the case is not a problem, that is another thing. But that will not be mediation in the right sense, that is another thing. It is not bad to settle the matters, that is another thing. Therefore, that we all the time we are going to do. The question is that we are going to use the alternative platform also. See, the point is we are already hard pressed for time. You are doing the work from morning to evening only. And then there is another platform which is there ready to parallelly do things for you. Therefore, we have to use those platforms also. That is why I will give you the information about that online platform also. See, you have to provide 2-3 mediation rooms. It has to be air conditioned or fan or whatever, chair, table we have to provide. And then somebody to open and close the door, so many staff is there. These are the advantages of these ODR platforms also. Once the platform comes, you refer to the mediator, he is going to sit at home. And we have to give him the login credentials and then he will do the mediation online. That is one great thing about the ODR also. Second thing, as you say, that it will all come only. Therefore, we started the mediation movement in the year 2005. We first started in the Court Annex Mediation Center was in the Madras High Court first. Then all the High Courts followed suit. Now, we are almost completing that every court complex has a mediation room or a mediation center. Even now, 4 or 5 courts in Tamil Nadu doesn't have. Every month we are opening new centers. Therefore, the mediation movement itself is from 2004 only. We all know the CPC amendment, then the Salem Bar Association case, and then the Law Commission's recommendation, second Salem Bar Association case. Thereafter only the court annex mediation centers were started to be opened from 2004 up to 20. Now we are only 21 years old, this mediation movement. As slowly comes, Act came, and then will come the centers, then will come the mediators, and then will the honorarium, everything. And then until the time it becomes a culture that it is not bad to pay a mediator its honorarium. That kind of a culture and awareness should go to the litigants. That will take another 10-20 years. Until then, as he says, that if you are going to ask the party to pay the honorarium, it is going to be a non-starter only. Therefore, we have
something like in commercial courts, section 12A, we need to have a mandatory pre-mediation before filing the complaint in the Consumer Commission.
Yes. Mandatory, all right. Now,
like in commercial court,
all right, commercial courts, it makes it mandatory. Now, your mediation act, as far as the other things is concerned, it is optional only. See, end of the day, again, mandatory also we are seeing in the commercial court, they are interim orders of petitions are filed and then it is being taken up. And how many it is there on law. You know, when you go and check the data with reference to that also, it is a little bit yet to take up. That is what simultaneously not only stopping with the legal provisions, and awareness has also to be created among the litigants that the purpose of law is that before you write your plaint, you put your pen down, sit and talk to the other side. Thereafter, if it fails, only write your plaint. That kind of a culture should be built up among all the parties. That is the difficulty. Yes, sir.
Sir, as we see, most of the consumer cases not settled before the mediator. In the final adjustment of compensation between the parties on the base issue. So, whenever the complainants are reported after the sale of the products or citizens of the needs, they must expect some compensation from the opposite parties.
Okay.
But the opposite was not ready to do that compensation amount. That is the reason most of the cases are not settled before the mediator. Apart from the fees.
Okay. See, there are two things which I want to tell you with reference to mediation as such. One is that if the mediation is conducted and if it is not settling, don't think that it is a useless procedure. As we said that the complainant has communicated in person to the other side why he bought that product or why he asked the builder to build the flat and what all he suffered. And the builder has communicated to the other side what was there, what are the problems, there were undue rains or lack of manpower or whatever it is, timely payment was not come. So there was an effective communication between the parties in every mediation in which the parties sit together and negotiate with each other. It has its own value. Even though ultimately the case is not settled and it is not closed, when parties sit and talk, the process itself has a value, number one. Number one, maybe as we say that culture is not yet come. The culture is not yet come to settle most of the cases. It will sooner rather than later it will come. Our first aim is to send parties. The challenge was to send the parties. Now the law is there. Now we are sending. Now we are in the second step. The parties are not coming. The second is the assembling of the parties. Now we are in that stage only. Now assembling of the parties and conducting the mediation is the second thing. Third one is only the output of the mediation is the third thing. And mediation output, we always say that any mediation in which both parties sat together in the mediation room and discussed the matters, it has its own value. Sometimes it may not be reported that it is settled or whatever the compensation is agreed. As you rightly said that many of these companies, they will think that alright, if I budge to him, then there is going to be many claims. There may be a strategic barrier for negotiation also. Therefore, if I actually for one product, for example, a particular model of a cell phone is a failure and therefore a consumer complaint is filed, then if he settles that amount, then all the 1 lakh fellows who purchase that model is going to come. Therefore, there may be strategic barriers, which is unique to the consumer complaints also. There may be strategic barriers for negotiation. But at the same time, we will provide some other opportunities also. You never know which case will settle, which case will not settle, is what the philosophy which we all believe in. All that we have to do is make an attempt, make a sincere attempt. Provide the parties the platform only, both physically as well as the ODR. We will try our best. As you say that the honorarium issue has to be why? All right, latest judgment, I have also given one judgment day before yesterday also. See, the point is that the Legal Services Authority Act said that if the matter is settled in the Lok Adalat, entire court fee has to be refunded. Okay? This will, the next sentence in the act is that this will have the effect of amending the respective state court fee enactment of this act. Okay? So that is the only this thing. Now the Maharashtra Act, they simply reproduce that if you settled in Lok Adalat, the entire court fee will be refunded. That is what was considered by the Honorable Supreme Court of India, and the Supreme Court said that the refund can happen only with reference to Lok Adalat, not with reference to mediation. But as far as Tamil Nadu is concerned, when we enacted section 69A, when the amendment was carried out, the section specifically said that the court fee will be refunded for any form of ADR. We specifically mentioned it. Therefore, the Supreme Court ruling will not be applicable to the states. You have to look into the concerned court fee provision only. Now, as far as Tamil Nadu is concerned, section 69A clearly says, originally it said that any form of ADR full refund. Now, at the time of referring itself, we say that it is a refund of the court fee. Therefore, now, even when you refer also, you have to refund. That is the Tamil Nadu Court Fees Act. Therefore, you have to look upon the concerned Court Fees Act only and then decide. The Honorable Supreme Court of judgment is with reference to the Maharashtra Act. Maharashtra Act specifically restricts only to the local. See, therefore, many of the states, I think Tamil Nadu, Kerala, I think Andhra Pradesh, I don't know about the Andhra Pradesh Court Fees Act, we'll look into it and we'll see when the Lordship take the class, I will come back to that thing also. Therefore, you have to look into the relevant provision of your state. Okay. Oh, all right. Okay. Then under which provision you can refund? Your own rules is there for refund. Oh, there is no provision for refund in consumer. Or okay. There is no rules in our consumer rules and regulations. All right. That can be done. That has to be done. Refund of court fees one concern, then on-roll is another concern. Yes.
Sir, one more thing. Snapdeal, e-commerce entity, in 2021, I guess, they have 110 this ODR experiment basis they have done. They have done a pilot kind of a thing, and they have been successful because 2021 and all, few of the consumer commissions were not in functional. So automatically they went for an e-commerce, alternative dispute resolution. And Snapdeal has started as a pilot study. Madam has questioned which service provider has done it. They have done it successfully and they have written a letter to Ministry of Consumer. It's only a research input I have given.
That's what. No. Even the experiment by the National University Bangalore was successful only. She wanted the percentage and the exact data. Okay. All right. She says that as far as Snapdeal is concerned, it was 50% in India. That's what they say. See, now in the new arena. See, two things which we all have to consider. One is that we already say that people who are born on and after the year 2000, they are all internet natives only. So they want to do everything only on the internet. Now after 2025, they are called the beta generation. They are saying they are born with the AI only. Therefore, if they come and we are going to see that they are doing all the papers. They are going to go away only. That court, they are sitting in that old chair and they are having some papers and they are doing some nonsense. So without the takers, where will we are? Therefore, that we have to consider also. Therefore, the persons, the ultimate users of the system, they are now used to doing things only online. Everything they do online only. Therefore, dispute also they try to resolve online only. Therefore, we must be aware of who our end users are and get equipped for that also. That is more out of necessity also we have to do, apart from the appropriateness and the advantages.
So one of the things I wanted to say is, in our commission, our hit rate in settlement is around 5 to 10%. Okay. Because what we have done is, since I practice in state commission, I understand how long appeals take. We have made it a policy not to give a lot of compensation. We just give the basic amount and the compensation. So therefore, we tempt them not to go for appeal and to settle the issue even in the order. So companies, you see, they get tempted to settle the issue. It is not mediation, of course, as my friend pointed out. But at the same time,
The middle path.
The consumer gets the cash in hand immediately. So then, therefore they are tempted not to engage the counsel for the appeal and finish the issue.
Rather than giving him an award on paper for 20 lakhs, if I award 2 lakhs, the consumer at least gets the check and the next
Yes,
month. That is what he wants to share his experience. That's a good point. And then the criticism is that the entire judiciary in India is very, very conservative when it comes for damages. That is the other thing.
Some of the manufacturers,
two schools of thought work together.
some of the manufacturers nowadays, what they are doing is by mediation, is if the consumer goes to the court, they have to pay monetary compensation. They are giving some vouchers of the value of the product, what is the complaint. So they are adopting for the mediations rather than going for the complaints.
Okay. That is, therefore, we have to, that's what, if one leads to the other. If there is a program, there is an experience. If there is an experience, it becomes a policy of the industry itself. See, for example, I went to a place called Thuthukudi in Tamil Nadu, where all these export houses, they have a policy, up to 10 lakhs, any recovery of the amount. If a dispute is a value of only 10 lakhs, they will file the suit in the local court. Between 10 lakhs and 1 crore, they have the arbitration clause, arbitration in Madurai or Thuthukudi. 1 crore and 10 crore, they say arbitration, seat of arbitration will be in Chennai. More than 10 crore, they are saying Singapore. That is, no, I'm saying how the companies are, for they think that they go there, it gets resolved earlier. Therefore, we are exporting litigation, importing law only. Therefore, that is why one leads to the other. There must be a start. We have to, now we are referring and then yes. See, you are exactly right. See, that is one of the long-term goal of all these area methods is to bring back those big fishes to our country only. Yes. See, that is what the drawback which you are saying, that when traditionally our techies or the engineers or the software professionals have that kind of a reputation worldwide, why are we not, we the lawyers and the judges are not having that kind of reputation, people are not having that kind of a faith, is something we all have to ponder. And unless that faith comes, those matters will go away only. That is the only thing. And one of the long-term goals of all these ADR methods, including these online programs, everything, use of technology, is to gain that faith of the litigants and to conduct those matters here only. That is one of the long-term goals. The thing is to prevent the docket exclusion only rather than the docket explosion. Okay. Anything else? Shall we end the session? Okay. Thank you. Thank you.
Thank you so much, sir. It was such an enlightening session. I must say, you are a Catholic judge, to say the least. And I would not be wrong if I call you professor of practice in our institution. Sir, for our hostel, it was a revisit to our classrooms. I'm sure most of them felt like that. Yes, sir. And I must say, sir, not many of us faculties could match your enthusiasm and the way you handled the class. Thank you so very much, sir. Now I invite Mr. Anupam to give vote of thanks.
Honorable Justice Sundar, respectable law college principal, Dr. Srinivasan, and our Honorable District Council President, Thiru Muthuvel, and the State Commission President is not very meeting, and the State Commission member, Madam Kumar Sukari, and my co-member, Smita, and all other respected presidents of State Commission and District Commissions, and members of Andaman, Andhra Pradesh, Telangana, and all other media persons and dignitaries on the dais and off the dais. I will be first convey my good morning and New Year wishes. Good morning, sir. Good morning, everybody. As far as the vote of thanks is concerned, when I entered the hall, Mr. Amit, I think, he told me that you finish the vote of thanks session as short as possible. Maybe because of his past experience. So, it will make my vote of thanks as short as possible. When our Lordship, Mr. Bharat Chakravarti, when he was explaining online dispute resolution, he was saying that it is a part of alternative dispute resolution. Alternative dispute is already there, the concept is already there, mediation, negotiation, local law, and so on and so forth. And one of which is online dispute resolution. Anyway, the dispute must be resolved in some manner or other. That is this is faster and this speedier. That is why this system has been coming into effect. And he has also spoken many of the pros and cons of all these online dispute resolutions. And he has a number of concepts he has given, and which are very new to us. We are not compared us before that, like the blind bidding mediation and directive mediation and F2F mediation. These concepts we are not so far compared us. Thank you for the way in which you have explained. And as well as the scales of articulation, the mitigation, and explaining of the concepts to you. So I don't think there is no compromise on that. I think 99% of you would not have seen him when he was a budding young student, but just I was some 2 years senior to him. And even when he was studying in the law college, I think second year, he explained his capability and caliber by what is studying in the All India Moot Court Competition. I have seen it, and I for that. Mr. Dr. Singh also would have seen him. He was very capable, and apart from that, he has risen to such a height, not because of his talent alone, he is very humble and simple. As Thiruvalluvar says, Adakam Amarul Vikyam, which means when you are not showing off what your talents are, you will become rise to higher positions. That's what Thiruvalluvar says. And I have seen him personally, even when somebody was standing and asking some questions, he said, you please sit and say. So that was his humbleness. So it reminds me of only one thing. So I will finish it as fast as possible. Only one thing. You know that one saying, Ramalingam Valala, he says that whenever you used to walk, when he says he don't, you will be hearing holding his hand, meaning that God is omnipotent, like Islamic principle, and whenever I walk with the bold hand and unfolded hand, it seems I disrespect the God. Therefore, he was always holding his hand. And apart from the God, you must see that he also said that எல்லா துறையும் கவிதேன் நான் வல்லாரின் வல்லவன் ஆனேன் இத்தனையும் பொது நடிச்சில் இறைவன் அருள் செய்கிறேன். He says that he is the mightiest of the mightiest person, but even then he is always holding his hand to show that he is respecting God. The same humbleness and the simpleness I am finding with the Mr. Bharat Chakravarti, and so I think this this abundance and coupled with the talent would take you to the higher forum. And I think that I hope that we all as well with the participants, they all wish that the days are not far off that you will be attending the chair of Supreme Court. Thank you very much for the opportunity which has been given to me. Thank you very much once again.
Data, Google says, I don't know how far it is true. When you ask for the data, that it says that since 20, I don't know how far where it gets from, since 2020, the value of the cases settled in India through online dispute resolution is 26.5 billion US dollars, that's what it says. And it says that over 36 lakhs cases have been settled. And they are saying about these things about more this banking and financial institutions seems to have their own this thing. So that data is only there. They are saying about PayPal, all these banking institutions, whenever the dispute arises, and then if it is resolved, I think they are taking into account as one case and then those things. We don't have the further data, but the thing is that since 2020, 36 lakhs cases have been settled, that's what they are saying. And the value is US dollars 26.5 billion, that's what they are saying. The further details are not available, I just Googled it.
Thank you so much, sir. Now we'll quickly take a 10 minutes break. We'll have tea snacks and we'll be joining here. We have Honorable Mr. Justice M. Sundar. We are eagerly waiting for his enlightening session, sir. Thank you.